Welcome to episode 81 on the law rapport. In today's episode, I'm going to discuss a question that was in box to me. What are tenants' rights after their fixed term tenancy ends? As you know, in this channel, I concentrate primarily on criminal law. So this is not my area of specialty, and I have done little research into the subject, but I'm going to try to answer it off the top of my head. Before I do, my disclaimer: I'm a lawyer, but I'm not your lawyer. Do not use anything that I say on this channel as substitute for advice from a competent lawyer of your choice. I'll be back shortly to discuss the subject at hand. Welcome back. What happens when a tenant signs a tenancy agreement in the Turks and Caicos Islands, referred to as a lease agreement, which may vary in length but normally last for 1 year? When the fixed term comes to an end, two factors come into play. One is whether the tenant is still in occupation of the lease premises, and two, if the tenant has moved out at the end of the tenancy. The general rule is at the end of the fixed term, the lease ends. This is under a rule known legally as effluxion of time, or is generally known as the lease ending by effluxion of time, which means that the tenancy or lease ends due to the passage of time rather than by the occurrence of a specific event. So it is part of the definition of a fixed term tenancy that it will start on a specific day of a month and a year, and ends on a specific day of a month and year. It can't continue any longer, as it was created only for that specific purpose. The significance of this for tenants is that if they have moved out, let's say by midnight, and the last day of the tenancy will end, and they will have no further obligation or liability under that expired tenancy, for example, for future rent. In reality, a landlord can't artificially extend the term by saying that the tenant will be responsible for an extra month's rent. That will be outside the term of the tenancy and will not be enforceable under the written lease agreement that just ended. If the tenancy agreement says, for example, the fixed term will end on the 25th of December 2024, then that is when it comes to an end. So if a tenant moves out by the end of the fixed term, they will still be liable for rent and other obligations incurred during the fixed term, but they cannot be held liable for anything after that. Therefore, what happens if a tenant does not move out but stays in occupation after the fixed term tenancy or lease comes to an end? And in the event the landlord is not pressing for the property to be vacated, but do not want to enter into another fixed term agreement, in this scenario, the tenant will have a new arrangement called a periodic tenancy, which will start immediately after the fixed term ends. In other words, a month-to-month tenancy. There are two ways in which this can happen. A new periodic tenancy will arise at common law. For example, if the tenant continues to occupy the premises at the end of the tenancy without any further agreement, an automatic periodic tenancy is created. In other words, a month-to-month tenancy. Some periodic tenancy may run from week to week, quarter to quarter, even year to year, but the vast majority runs from month to month. In this new created tenancy, the landlord is at liberty to raise the rent or decrease the rent as he sees fit. If a tenant refuses to vacate the premises and do not pay rent after the tenancy ends, or if the landlord refuses to accept rent or accept rent on condition that there is no tenancy, then the tenant will be an holding over tenant and can be evicted through the courts on the basis that they have no right to remain on the property. This situation is quite rare. However, there can also be what is called a contractual periodic tenancy after the fixed term tenancy ends. This is where a periodic tenancy arises by agreement between the tenant and the landlord. The advantage of this for the landlord is that they can control the period of the tenancy rather than risking it being a long period. If, for example, the landlord want the premises or want to repurpose the premises or want the premises to be vacant within a specific time frame, a periodic tenancy, whether at common law or contractual, may be terminated by either party that is the landlord or tenant, by giving 1 month's notice. If the matter gets complicated and the tenant refuses to leave in either a fixed term tenancy when the fixed term comes to an end, or a periodic tenancy, whether at common law or contractual, my advice to the landlord is to petition the court for eviction notice. Do not take any actions such as changing locks, removing windows or doors, which may put you on the wrong side of the law, causing you to incur liability for unlawful eviction. So to answer the question posed, after a fixed term tenancy comes to an end, the tenant and the landlord can enter voluntarily into either a contractual periodic tenancy or a tenancy at common law if the landlord agrees that the tenant should continue occupying the premises but does not want to enter into a fixed term tenancy. I hope this answers the question. Here's where I'm going to end this episode for today. And if you like this episode, please give it a thumbs up. And I will see you very shortly in another episode. Cheers.